Okay, wonderful. So we're going to go ahead and get started. Hello, everyone. I'd like to welcome you to Ballotpedia's first webinar in our You Ask Ballotpedia Answers series. Today, we're going to be talking about non-delegation, which is one of the 5 key pillars of the administrative state. The non-delegation doctrine is a principle of constitutional and administrative law that holds that legislative bodies cannot delegate their legislative powers to either executive agencies or private entities. In other words, lawmakers cannot allow others to make laws. Here with us today to answer your questions are the members of Ballotpedia's administrative state team, Chris Nelson, Jace Langton, and Caitlin Stiersky. Christopher Nelson is Ballotpedia's chief editor for policy. He has been with Ballotpedia since 2014 and previously worked alongside Jace and Caitlin on the Influencers Project, as well as most recently on our coverage of the administrative state. Caitlin Stiersky is the deputy chief editor for policy. She has been with Ballotpedia since 2015 and previously worked on both the Influencers Project and the State Legislators Project. Jace Langton is Ballotpedia's policy staff writer. He has been with Ballotpedia since 2015 and has worked on the Influencers Project as well as on a range of policy topics, including most recently the administrative state. Anybody is free to ask a question. If you have a question, you can type ask a question to add your question to the queue, and then the questions will be answered in the order they're received. We do already have some questions, so we're going to go ahead and get started with those. For our first question, an audience member would like to know, if the non-delegation doctrine isn't explicitly mentioned in the Constitution, where does the idea of the non-delegation doctrine come from?
Good question. I can start with that one. The idea comes from a combination of social compact theory and the vesting clause, which is found in Article 1 of the US Constitution. So it's a combination of practical politics and political philosophy. The vesting clause says all legislative powers herein granted shall be vested in the Congress. And scholars have argued that the Constitution did not give Congress the authority to transfer its legislative powers to other entities, either the judicial branch or the executive branch or to the states. That, along with the fact that the American people delegated their original legislative authority to Congress through the Constitution, led some scholars to conclude that Congress cannot further delegate that authority. That conclusion is what we call the non-delegation doctrine. So the other way people establish the non-delegation doctrine is through the concept of enumerated powers. That means that branches of government can only do what the Constitution empowers them to do. And since there's nothing in the Constitution that says that the president or the courts can exercise legislative power, people say that that implies a non-delegation doctrine and that Congress is the only branch that can exercise legislative authority.
And beyond the Constitution, obviously philosophically, to the extent that this idea is related to the notion of separation of powers, this idea precedes the Constitution, even the 18th century, and thinkers as like Locke and Montesquieu, who were concerned about how to restructure political power and distribute it amongst different branches in order to avoid what in their time were perceived as abuses or over-centralization of political authority. It's interesting too, I think there's a meta way of analyzing this question in a lot of the scholarship around the non-delegation doctrine. What you sometimes see are either arguments for and against the very existence of a doctrine, and then there's another category of arguments about whether it's a good idea to have one or not. And so on the one hand, although it's not in the Constitution explicitly, some, on the one hand, could infer it being there. On the other hand, regardless of what the Constitution says or doesn't say, there are other arguments in a more modern context about how there maybe needs to be one, right? So even if it weren't there, some would argue there should be something that we talk about now, right, that puts some constraints on the delegation of legislative authority. So there's sort of 2 ways of sort of thinking about this constitutional question that you sometimes see written about, or implicitly or otherwise, in the scholarship around this area.
Our next question is, so one of the readings in the non-delegation expedition was Entering the Non-Delegation Doctrine by non-delegation doctrine opponents, Eric Posner and Adrian Vermeule. Posner and Vermeule refer to the non-delegation doctrine as a legal fiction. What do you think about that?
I can take a stab first. I mean, I suppose that on sort of a superficial level, it makes sense. If it's not in the Constitution, then I guess someone, in their view, must have made it up. It's a legal fiction. But I mean, I think if you dive more deeply into their paper, I think that they make an interesting argument about how, in their view, and this isn't entirely their view, a number of people believe this, that what you actually see in the form of administrative rulemaking isn't so much an extension of, delegated legislative authority as it is just the function, the exercise of executive authority. And so almost by definition, on their view, nothing has been delegated. This is simply agencies doing what executive agencies are allowed to do in the constitutional structure. And so, and it's an interesting way of sort of kind of sidestepping. It's an interesting way of sort of reframing the question again, like executive agencies do executive sorts of functions. And so again, on that view, it's like whether it's a legal fiction or not, they believe that you're not even actually talking about legislative authority having been delegated in the first place. So it's an interesting, so, again, I understand where they're coming from, but again, they go a little bit deeper beyond even whether or not it's a legal fiction. They have an interesting argument for what the executive agency actions actually are in their view that's really worth examining.
I think the most interesting meat of the article is that Posner and Vermeulen are arguing that congressional delegations of authority to agencies allow those agencies to exercise executive power to carry out their statutory obligations. And so since the agencies aren't actually exercising delegated legislative power in those cases, there's no delegation problem, according to the authors, that would even need to be addressed. So it's an interesting, compelling argument.
And another one of the papers for this expedition, Resuscitating the Non-Delegation Doctrine, a Compromise and an Experiment, A.J. Kritikos mentions the line drawing problem that occurs when trying to delineate a permissible delegation from an impermissible one. What are various ways people have suggested to help draw that line?
I guess I'll go back to 1928 in the J.W. Hampton case. Chief Justice Taft put forth the intelligible principle test, which is a test that's still used by the court today, and it's probably the most popular instance of a line drawing test that we can refer to here in this context. The test concludes that the legislative action isn't a forbidden delegation of legislative power in certain cases when the line between authorized and unauthorized delegations of power direct the delegation. I think the intelligible principle test is probably one of the first efforts at drawing a line between permissible and impermissible delegations. But there's really no settled answer. And if you look at the Kritikos paper, the case study about Florida, there's a line drawing issue between civil and criminal delegations of authorities. So I'll kind of let the other guys jump in here if they have.
Yeah, I think in a way what's so challenging about this question is it's not entirely practical. It's not simply about knowing where the line is and where to draw it and then knowing how to understand when someone's crossed it, and then even the practical question of then knowing what to do in enforcing sort of like line crossing. I think scholars are now reckoning with having to understand what legislation even is, sort of going back to first principles before we understand what's been delegated away, understanding what legislative authority is in the first place. And so that's provided some interesting new sort of research agendas for scholars sort of grappling with the line drawing question itself. Yeah, I mean, Caitlin mentioned sort of the interesting things happening in Florida. This Kritikos paper is really valuable for that case study that also shows that whatever we think about and whatever scholars have thought about the non-delegation doctrine as a doctrine at the national level, which is where it's often discussed, clearly things are happening in the states and have been in the Kritikos paper provides an interesting lens into that. And I think that one of the most persuasive frameworks I think I've found for, and which Kritikos gets into, for sort of understanding what we even mean by this line drawing problem is one way of potentially of addressing it is sort of understanding that certain things can be delegated, say the discretion, certain sort of technical, practical matters of discretion to agencies without handing over the entire sort of core essence of the lawmaking function, right? So that you might say, maybe you draw the line by delegating to the EPA, say at the national level, some sort of particular discretion to make some tweaks to the amount of pollution particulate in the air. But what you're not delegating to them is the very idea that the air should be regulated by statute or rules, right? So that it's still, so that as a policy question, it's still a function of the lawmaking branch. It's just that maybe particular matters of practical discretion are, for lack of a better way of putting it, sort of delegated away. So drawing the line between sort of the core essence of the lawmaking function versus some of the very practical, technical sorts of things that maybe the agencies on the ground would have to handle. And so that's one way I think some scholars have grappled with, even making sense of this line drawing question, sort of which different functions would seat on different sides of this line.
So we have a participant, and she'd like you to go into, if you could, a little bit more detail about how the non-delegation doctrine applies at the state level, specifically in the state of Florida.
I'll just take a quick stab. I mean, the Kritikos paper gets into this a bit more. It's a slightly older paper at this point, but still a valuable case study. One of the interesting things that I think it shows is that so much of this is so context dependent on a variety of factors, including just the different sort of culture of the law in different states. And so it's funny. There's just different cultures of enforcement around these different ideas in the state court system. There's just a sort of a different sort of mentality around thinking about this. Of course, this has then affected sort of the structure and sort of the nature of the adjudication of different rules. One of the really interesting things, and I'm gonna riff a little bit. This isn't about Florida particularly, but what's interesting we've seen in the last year with a lot of the reaction to a lot of the executive action related to the coronavirus. There's been a lot of different responses in different states. I'm thinking of Michigan in particular that actually relied on the non-delegation doctrine, for instance, to push back against gubernatorial emergency executive powers related to the coronavirus lockdown. And it just goes to show that although some of the scholarship around this question sort of tends to assume that this is something of a dead letter as a doctrine in the states, as Kritikos's paper sort of shows, and as last year showed, again, in the case of Michigan, several other states, courts are looking to this and leaning into this doctrine as a way of addressing legal challenges to certain executive action.
Mentioned that, some people see it as kind of this dead doctrine. And one of those people is Professor Gary Lawson. And he says in his article that the non-delegation doctrine may be dead as a doctrine. And do you guys agree with that or no?
In fairness for Professor Lawson, just like the Kritikos paper we were talking about, he wrote this article even longer ago, so it's been a few years. It was more dead when he wrote the paper, I'll say that, but not anymore. He's right to the extent that the Supreme Court has continued to refuse to rule that any statute that it's considered has contained impermissible delegations of legislative power, and that's been since 1935. So it's been almost 100 years, and the Supreme Court has not struck down or ruled unconstitutional any kind of statute on non-delegation grounds. So in that sense, yes, the doctrine is dead. But in 2019, 4 of the justices said that they would revive the doctrine if the right case came along. And that was in the Gundy v. United States decision. And then later, when Justice Kavanaugh was on the court, he said he would also be open to applying the non-delegation doctrine in the right case. So that means the majority of the current justices are at least open to ruling that a statute gives away too much legislative power to agencies. So they're just waiting on the right case to come. And you would think, given that invitation, that there are probably some enterprising lawyers trying to make sure that that question comes before them sooner rather than later.
Yeah, and again, just to build on the state examples, again, so much of scholarship in general around questions of administrative law or administrative state are understandably focused on the national government, given its size and complexity. But again, obviously, every state government, every municipality has elements of administrative law and administrative state. And at that state level, we've seen for years lots of little sort of applications, again, notwithstanding last year's sort of fairly major sort of rebuttals of certain emergency powers relying on separation of powers clauses and non-delegation doctrine theories. But we've seen for years state courts rule in sort of nuanced ways with reference to non-delegation doctrine, maybe not entire sort of statutes getting turned down, but maybe particular rules coming out of state agencies. So in the states in particular, we've seen it not be a dead letter for some time. And again, as Jay says, I mean, a number of justices on the U.S. Supreme Court have certainly hinted that they're interested in re-examining the doctrine.
Yeah, and I'll just add, there's also been some great recent scholarship on the topic of the non-delegation doctrine in the states. There's a paper from Benjamin Silver that was recently released that examines what he refers to as kind of the inconsistency around non-delegation jurisprudence at the state level. But he argues that state approaches to the non-delegation doctrine are actually rooted in common themes. Those themes are drawn from the separation of powers and sovereign authority. There's also a recent paper from Daniel Walters that also examines the non-delegation doctrine after the Gundy case in particular. And his examination found that the doctrine at the state level, some states actually adhere more closely to the intelligible principle test than others. So the non-delegation is alive and well in the states, but it's just applied differently.
And another audience member would like to know, for all proposed regulations, they're published in the Federal Register. The public has input to the process. Why is the non-delegation doctrine something that some people feel very strongly about? What is not covered by the way the processes are in place now?
The proponents of the non-delegation doctrine would respond that just because the public is involved in the promulgation of regulations doesn't solve the constitutional defect that they found. So yes, public comment and being able to send in your views to a federal agency as they're making policy is a way to try and increase accountability to the public when they're rulemaking, and that is definitely a goal when we're talking about laws and regulations. But the objection that proponents of the non-delegation doctrine are making is that Congress isn't involved enough in making these policy decisions. So even if, yes, the people are directly involved in policy in that way, Congress is still cut out of that process, and they're saying that the Constitution requires more action from Congress in these areas.
Speaking of arguments in support of the non-delegation doctrine, what's the argument in support of it that you personally find the most powerful?
Me personally, I'm kind of a nerd, so the argument that appeals most to me is that the idea is of the non-delegation doctrine being rooted in social compact theory. And that's the idea that people come together to form society on agreed upon terms. You give up your individual sovereignty to resolve disputes on your own and submit to a common judge, so that if you have a problem with someone else, you've both agreed to recognize that authority to answer some questions. Going back to the Declaration of Independence, if just governments derive their powers from the consent of the governed, then the non-delegation doctrine is just one way that the constitutional system honors government by consent. And that's one thing that proponents of the non-delegation doctrine say. If the people delegated their legislative power to Congress, so they consented that Congress would exercise legislative power through the Constitution, then the non-delegation doctrine enforces the will of the people in that way by making sure that only Congress exercises that power.
We should say there's a range of different arguments for, against, and related to the non-delegation doctrine that you can find cataloged at Ballotpedia. Yeah, and again, I am always fascinated by, there's really sort of two things we mean by these questions, which is really, what are the strongest arguments in favor of its actual existence, and what are arguments in favor of it needing to exist. And I sort of feel like perhaps the most persuasive of its actual existence, just in the national context, is again something like the vesting clause, which implies a separation of powers, which I think implies a non-delegation doctrine. Interestingly, I keep referring to the Michigan case last year, which was effectively a use of the non-delegation doctrine. Interestingly, Michigan doesn't have a non-delegation doctrine clause, but it has a separation of powers clause, which the court used to infer a non-delegation doctrine in the state statute, which is what they actually used to then put the executive action down. In terms, though, of arguments in favor of it needing to exist, I think, kind of building off what Jay said about social compact theory, I think it takes largely the form of sort of a given if-then statement. I think given the way the framers intended to divide the powers that we delegate to it among the branches of government, right, to avoid some centralization of power in one branch, non-delegation doctrine is one of a set of tools to ensure that the powers remain distributed.
How about the converse? What's an argument against the non-delegation doctrine that you find persuasive?
Yeah, I think the most persuasive argument there is that there's no non-delegation doctrine explicitly in the Constitution. That word doesn't appear, as far as I've been able to tell. I think it's not until Field v. Clark where they're talking about it as this big doctrine. Obviously, the idea had been around before 1892, but the fact that you can't just open up your pocket constitution and find a non-delegation doctrine should give proponents pause. At least it's harder to argue that there is a non-delegation doctrine than it is to say that Congress has the power to establish post offices. That's clearly in Article 1, Section.
Yeah, and kind of building off what Jay said, I think the argument that we already kind of touched on, put forth by Posner and Vermeule, which states that agencies exercise executive power when they implement statutes, is a really compelling argument against the non-delegation doctrine. But since there's no clear consensus on what type of power agencies are actually wielding when they implement laws, whether that's executive or legislative power, I think we're going to continue to see a debate about the non-delegation doctrine in that context.
I think one argument you often see proposed as well by opponents of the doctrine is that if the doctrine were strictly sort of adhered to, then government couldn't function, right? And so if you can't delegate powers from one branch to the executive in order for the executive to then implement the laws of Article 1, then how can executive branch do any of the work that in theory it's supposed to do? And so there's an argument about just this sort of the practicality and the need to sort of provide some sort of, I don't know, sort of lubricant to sort of make the system work, and the non-delegation doctrine sort of frustrates that process. I do think the technical distinction that Posner and Vermeule make is an interesting one, that effectively what we are talking about when we talk about rules really is not, lawmaking, right? Thus, there's no delegation of legislative authority. Thus, we don't really even need to talk about any violations of a non-delegation doctrine. It's important because I do think sometimes some legal challenges that are often couched in terms of the non-delegation doctrine or violations of the non-delegation doctrine may in reality just be lawsuits concerned with the legitimately delegated legislative authority that they just believe the executive branch or some administrative agency has now run too far with, right? So it's not that they believe some executive action is actually violating the non-delegation doctrine. They believe that the power is duly delegated and now it's simply sort of just gone too far in some direction, right? And so there's a bit of nuance necessary in sort of analyzing which cases are brought in the name of the doctrine versus sort of couched in the language of it. And I think that those technical distinctions that Posner and Vermeule make are very important ones to understand and provide a really important amount of nuance that I definitely think, based on the scholarship, definitely are found to be very persuasive.
And then we have another question, and somebody wants to know, what are the most important court cases about the doctrine?
I have a short list I like to refer to. Non-delegation doctrine proponents like to point to Justice Marshall's definition of the doctrine in Wayman v. Southard, and that's an 1825 case. He said Congress can't delegate what are strictly legislative powers, but he acknowledged that there's a line drawing problem way back in 1825 and said there's a difference between the important things that Congress must decide and then they're allowed to delegate in situations where they can allow others to fill in the details of a general policy. And then after that standard, you had Field v. Clark in 1892, which upheld tariff statute as an example of contingent legislation. So there was someone who had objected to the president getting rid of duty-free status for some companies in the case where the president found that some other countries had put tariffs on America. That's an important case because it's one of the first where the Supreme Court articulates the fact that there is a non-delegation doctrine, even though they ended up upholding that statute. The next two important cases are Schechter Poultry and Panama Refining Company, both decided in 1935. Those were the last cases where the Supreme Court struck down legislation for violating the non-delegation doctrine. Also, J.W. Hampton, as Caitlin mentioned earlier, that was where the Supreme Court laid out the intelligible principle test. Whenever a modern court is looking at a question of non-delegation, up till recently with Gundy v. US, the justices had been applying that intelligible principle test, and if Congress set down any kind of parameter, they were going to uphold whatever Congress passed. And then Gundy, obviously in 2019, was a big marker saying, oh, the court might be open to reviving this way of evaluating statutes in the future. So those are the big cases I would look to understand the doctrine.
Yeah, and reading the various opinions and dissenting opinions, I think, is very crucial in the Gundy case, because I think that's where those clues are where many of the justices have signaled again that they're open to reconsidering. And I sort of wouldn't be surprised if more cases are brought before the court in the next couple of years. And so I think look to the lower courts to see which cases are bubbling up that are using the language of non-delegation doctrine. And I think there's one recently, right, Jace, the Texas Keystone XL pipeline lawsuit, where I think an executive order sort of removed some sort of license or access to, and I think that there's a challenge now. There's a legal challenge against the federal government, I think, partially on non-delegation grounds. And so people are still trying, and I think presumably because I think they're reading the tea leaves, there are a number of justices, again, openly signaling in various opinions, dissenting or otherwise, that they're open to hearing, sort of new angles on this topic.
That's right. It'll be interesting to see how the different circuit courts handle these questions as they come up. If any of those judges take the opportunity to try and audition for higher office at the Supreme Court, as people are looking to add justices or replace justices, it'll be interesting to see how they handle the questions.
An audience member would like to know if there's kind of this tension between the idea that there are some people who say that you have to delegate in order for a modern government and society to be able to run smoothly. Have any of those people ever proposed explicitly amending the Constitution to allow for delegation?
It's an interesting question, and one thing, if anything, right now that is worth looking at is that right now there are 40 states with constitutional statutes explicitly sort of establishing a separation of powers clause, which again, in the view of many, sort of would imply some non-delegation doctrine. So if anything, I think there's potentially some momentum around actually clarifying those statutes and doctrines in their constitution, or in the states in which it doesn't exist, potentially adding that language. So instead of sort of, making a more explicit sort of pathway, shoring up what's meant by some of the things that many think exist to sort of do this work, which then obviously in the negative would then sort of provide a clearer path for about which things are permissible or not. But it's definitely an interesting question.
Okay, and then someone would also like to know the constitutional originalists who support the non-delegation doctrine kind of reconcile those two ideas, given it's not explicitly mentioned in the Constitution, it's implied, but doesn't that kind of cause an issue for, originalists? Or like, why do they think that the implications of the separation of powers implies that the doctrine must exist, even though the Constitution doesn't state it?
So for them, that goes back to, like I mentioned before, the idea of enumerated powers. If the Constitution specifically sets up exactly what each branch of government is supposed to do, then they're trying to apply the text of the Constitution as strictly as possible. And so with the necessary and proper clause in Article 1, they've already acknowledged that there are some implied powers. If Congress can pass a law to do any of the explicit things that Article 1, Section 8 lists, then there are other things that they can pass laws about in order to affect those things. And so using a similar logic, if Article 1 only gives Congress the power to make law, these judges are saying that they have to hold Congress to that standard. And that's the whole debate between formalism and functionalism. The functionalist argument, which is the one you just articulated, is, okay, that's fine, but if we apply the Constitution in 2021, the government will break down. Formalist judges might disagree or agree with that point, but they say that their job is to apply the law as they see it anyway, regardless of the consequences. And there are different approaches to judging, but the judges who are applying the non-delegation doctrine in the way that the questioner is talking about are looking at trying to make sure that the law that was actually passed, including the Constitution fundamentally, are applied as written. And then if they need to be changed, allowing the people or Congress to change the law or the Constitution.
It's a really interesting question, and it's an important challenge. And I think that it cuts both ways, though, to some degree, because while there's no explicit sort of non-delegation clause right alongside the other things you could infer from the vesting clause or other elements of the Constitution, there's also no explicit set of rules establishing, say, a federal administrative state in the Constitution, right? So, the implication of it not being there in many view is that, well, the framers accepted a delegation as just a sort of a natural sort of function element of government. But again, if that's true, if they thought that at the time, if they understood the consequences that the executive branch would then need to do all of this work in sort of receiving this delegated authority or presuming delegated authority in order to interpret legislative intent, then again, you could imagine they would have wanted to spend a lot more time on Article 2, right? And so, and they didn't. And so again, on a strictly originalist ground, you may not see strictly originalist textual support, say, for the modern administrative state. So again, that it's an important challenge, but it potentially cuts both ways. But the really interesting thing is that there's an incredibly robust subfield of administrative law historical studies on trying to understand what the framers thought about these questions, and on delegation doctrine, judicial deference to agency interpretations. And you can find about as many arguments from one framer thinking this as you can from that one framer saying something seemingly sort of opposite. But there's an amazing, robust cottage industry now trying to understand how to interpret modern administrative law in the context of debates by the framers around the founding. It is true that at the end of the day, the most interesting thing is that whatever we find out about what they believe, the interesting thing about the non-delegation doctrine, at least in the view of some proponents of it, is that whatever is the case about the founding or the framing or what the framers thought, there may still be some independent reason for it to exist today, right? And so whether it exists in the Constitution, some proponents argue it needs to exist either way. But the historical debates are raging and are fascinating, and have become a really core sort of window, a laboratory for sort of modern debates about administrative law, just again contextualized in the language and the words of the framers and the framing.
In that case, I think we're ready to wrap up for the afternoon, and I'd like to thank everyone again for coming. The next webinar that we'll be hosting in our You Ask Ballotpedia Answer series will concern judicial deference, another pillar of the administrative state, and will take place on July 26th, also at 5 p.m. Eastern Time. So thank you again for coming, everybody, and I hope you have a wonderful afternoon.